Hey folks, so good day guys, my name is Scott and welcome to another episode of my lecture. So it's Law of Thoughts. We are going to look at the Law of Thoughts. Earlier on I had promised to deliver a lecture on the Law of Thoughts. So today is that day, so pay attention. And so we are not going to look at the whole of it because Law of Thoughts is a very wide unit, but we are going just to break it into some parts. You're not going to study some parts under this Law of Thoughts. So we are going to cover it, but procedurally. So Law of Thoughts, you're going to look at negligence. So negligence is whereby there exists a specific duty of care. There is a duty of care. If you want to understand this negligence, you must know that there must be a duty of care. So there's this duty of care whereby a reasonable person is expected to do some things, and so these are things which a reasonable person is expected to do. Okay, let me establish a case whereby there is a breach of duty of care. So this is where a person does things which a reasonable person is not expected to do, or he fails to do things which a reasonable person is expected to do. So the law demands that a reasonable person has some things to do that he is supposed to do, and there are things which a reasonable person is not supposed to do. So there are people who have some legal duty of care, like a teacher has a legal duty of care to the students, a driver has a duty of care to the passengers, and a road user has a duty of care to the other people. If you are a pedestrian, you are a passenger, you have that legal duty of care. A manufacturer of goods has a legal duty of care to the consumers, and a doctor owes a legal duty of care to the patient. So there's this just duty of care that you are just supposed to act in a particular way. If you fail to act in that particular way, then you have breached your duty of care. Do you understand? You are getting it. So you are just supposed to act in a particular way according to the law. So the law has provided some instances whereby you are supposed to act, or it has created a presumption on a reasonable person, or what a reasonable person is expected to do. But when you omit to do those things, then you have breached your duty of care, then you have neglected, or there is negligence. So I think you have understood on what negligence is. So we are going to look at the elements of negligence. So there are three elements of negligence. The element number one is the legal duty of care. The element number two is the breach of duty of care. What will it result? It will result to the element number three, the damages. So there are three: legal duty of care, the breach of duty of care, and the damages. So the legal duty of care. So the legal duty of care is defined by the law what a reasonable person is expected of, or is supposed to do, or what he is not supposed to do. Or when you breach that legal duty of care, you have done something which a reasonable person according to the law is not supposed to do. So you will have omitted to do what you are supposed to do, then you will have breached the legal duty of care. So before we look at the proximity and before we look at all the two elements, the breach of duty of care and the damages, let us first look at the legal duty of care. We said there are three elements: legal duty of care, breach of duty of care, and damage. Please don't confuse. There are three elements of negligence: the legal duty of care, the breach of duty of care, and the damage. So the legal duty of care, that's element number one. You can write down the legal duty of care. The legal duty of care. So the legal duty of care we might call them elements, has three elements. So for maybe let's take an example: you are a defendant, you have been accused of negligence or neglecting some responsibility. So for you to escape from liabilities. You must prove that you couldn't foresee what is being accused of you. Then there was no proximity, and there was no it wasn't just unfair. So there are three should I call them sub branches or elements? Just call them elements under this under this legal duty of care. We say there are three elements of negligence: legal duty of care, the breach of duty of care, and the damages. So we are looking at the legal duty of care. So the legal duty of care has three elements. I said I will refer to them as elements. So maybe those sub branches, the elements. So the proximity. These are basic things under this legal duty of care: the foreseeability, just and reasonable circumstances, and the proximity. So let us look at foreseeability. So foreseeability is whereby you could foresee, maybe the act which was committed you could not foresee as a defendant. You could not foresee what happened. So you cannot be accused of breaching the legal duty of care because you are not able to foresee. So we are going to look at the case laws for you to be able to understand well. So there are two case laws. I think the cases are the Kings versus Phillips and the Bohill versus Young. So under foreseeability, those two cases, the case of Kings versus Phillips, this is a case whereby the case of Kings versus Phillips, this is whereby the defendant was accused of causing causing the plaintiff to sustain some nervous shock. So the defendant was reversing in front of his house. I don't know if he was a she or he. So as he was reversing, there was the child to the plaintiff, was riding the bicycle around there. So in the second floor, the defendant had some screams from the child. So the child wasn't knocked down, but there was just that, the child thought that he was going to be knocked down by the defendant. So he screamed. So the defendant had, and he sued that he had sustained nervous shock because of that. So the defendant was sued, but the court held that the defendant could not foresee that the accident could occur. So there was no foreseeability. So for the case of Kings versus Phillips, there's an important case of Donoghue versus Stevenson. This is an important case, and this is a case that establishes the law of negligence. So this is a case whereby the plaintiff sent a messenger to buy him a bottle of beer. So this defendant went and bought the bottle of beer while the defendant while he drank the bottle, we find that there was a snail in that bottle. So he went and sued. So let us look at this case of Donoghue versus Stevenson. Donoghue is Donoghue. So the case establishes the elements of negligence. Mrs. Donoghue consumed part of a drink which contained decomposed snails in a public bar, Paisley, Scotland, and claimed that it had made her ill. The snail had not been visible as the bottle of the beer which it was contained was opaque. Neither the friend who bought the beer for her nor the shopkeeper who sold it were aware of the presence of the snail. Mr. Stevenson was the manufacturer. So Mrs. Donoghue couldn't sue Mr. Stevenson because he did not. Okay, Mrs. Donoghue was. So Mr. Stevenson was the manufacturer. Mrs. Donoghue couldn't sue him because there was no contract entered between him and the manufacturer. Between she and the manufacturer, Donoghue is a she. So this is whereby Mrs. Donoghue consumed a beer which contained decomposed snail. So she sued because this beer caused her to get ill. So the court held that the shopkeeper, neither the shopkeeper nor the one who was sent to buy the bottle of beer was to be sued because they couldn't foresee. So the manufacturer was the only person to be sued here because he had that responsibility, that duty of care. But the court held that so Mrs. Donoghue sued the wrong person. So she sued the shopkeeper instead of the manufacturer. And she could also not sue the manufacturer because they had not entered into a personal contract. Do you understand? So so she couldn't sue the shopkeeper. So that is the case of Donoghue versus Stevenson, a case whereby there is a snail in a bottle, an opaque bottle. The bottle of beer causes the plaintiff to get ill, so the plaintiff cannot sue the shopkeeper, neither can she sue the one whom she sent to buy the bottle of liquor. So she's there, she's stranded. She also cannot sue the manufacturer because she did not enter into a contract with the manufacturer. So that is the case that establishes these elements of negligence: the proximity, the just and reasonable circumstances, and the foreseeability. So the second element of legal duty of care is proximity. So under proximity, this is whereby there exists that closeness. So before that, I have forgot. There's also another case under foreseeability, the case on Bohill versus Young. So another element of legal duty of care is so before I move to proximity, let us look on this case of Bohill versus Young. So in this case, the appellant claimed damages against the estate of the respondent, now the deceased. The deceased, who due to his negligence riding on a motorcycle was involved in a collision with a motor car. The appellant was getting off a tram when she heard the sound of the collision some 50 yards away. At no time, so she saw the pool of blood, which caused him to sustain nervous shock, I think. So yeah, so let me explain. The case of Boeing versus Young, this is a case whereby the applicant was alighting from the tram, which was 50 yards away from the motorcycle of where the accident occurred. So this is an accident whereby the owner of this motorcycle, who is the deceased, is dead. So is being accused by the applicant that he caused him to sustain nervous shock because this applicant, they are no. So the applicant or the plaintiff claims that he suffered nervous shock or those nervous shock because of the accident that was caused by the deceased person. So she says that she saw blood which caused him nervous shock. So the court ruled that there was no foreseeability because this owner of the motorcycle couldn't foresee that at that time the plaintiff was to pass there, so that she could not foresee. There's no foreseeability. So and foreseeability, I said we have three cases. We have the case of Donoghue versus Stevenson. We have the case of Kings versus Phillips, and the case of Bohill versus Young. You have three cases under the foreseeability. So these are just under the legal duty of care. I said legal duty of care has three sub-elements: the foreseeability, just, and fair just unreasonableness or reasonable circumstances, and proximity. So forcibility, there are three cases: Donoghue versus Stevenson, Kings versus Young, but you Kings versus. So the case of Donoghue versus Stevenson. So this is a case that was established on 1928, August 26th of 1928. So Mrs. Donoghue went and bought beer from a shop, from maybe a club, a pub. So Mrs. Donoghue sent the messenger, not a messenger, sent a pass. So Mrs. Donoghue sent someone to buy him a beer in a club. So the beer was bought. So while she consumed the beer, she found that it had a snail, a decomposed snail. So the beer caused him to become ill. So this beer was in a translucent, it's not an opaque bottle. So you could not see what the beer contained or what was inside the bottle. So Mrs. Donoghue went and sued the seller of that beer. But the court held that Mrs. Donoghue could not sue the seller of the beer because the seller of the beer could not foresee that the beer had a snail. Because this is how someone, a shopkeeper. You know, a shopkeeper has been brought some products from a manufacturer. So she does not know if these products are safe or not. His purpose, no, his function is no. What for him is just to sell those products. So the one for Mrs. Donoghue to sue the shopkeeper, it was not right at all because the shopkeeper could not foresee. So Mrs. Donoghue could not also sue that person who was sent because he was not also able to foresee that bottle had a snail, and that snail could cause illness to Mrs. Donoghue. So the only person here who could be sued is the manufacturer, who is Mr. Stevenson. So Mr. Stevenson is the manufacturer, the only person who can be sued. But for this scenario, Mrs. Donoghue cannot sue the manufacturer because the manufacturer did not enter a contract with Mrs. Donoghue. The manufacturer entered a contract with the shopkeeper. Do you understand? So the manufacturer entered a contract with the shopkeeper. So Mrs. Donoghue suing the manufacturer is not, it cannot happen because the contract was not entered between them, but it was entered with the shopkeeper. So Mrs. Donoghue was left with nothing to do, so she cannot sue the shopkeeper, she cannot sue the one she sent, and she's suffering because of the snail that was contained in a bottle of beer, which is opaque. So that is the case that establishes this law of negligence. So there are many aspects of negligence. So you can see that there is that forcibility under the legal duty of care. So the forcibility. So under the legal duty of care, we are saying there are three cases: the Kings versus Phillips, the Donoghue versus Stevenson, the one that establishes the elements of negligence, and the case of Donoghue versus Young. Those are the three case laws under the forcibility. So, and let us proceed to the other sub-element. I call them elements. So the another element of legal duty of care is just unreasonable circumstances. So for you to prove this, or for you to escape liability as a defendant, you must show that it was not just and there was no reasonable circumstance in that case. So another one is proximity. So proximity that establishes that close relationship or that closeness. So this case of Donoghue versus Stevenson, Mrs. Donoghue sent a friend to buy a bottle of beer for her. So the friend went and bought a bottle of beer from a shopkeeper. So when Mrs. Donoghue consumed this bottle of beer, she found out that the beer had a decomposed snail, and while she consumed this bottle of beer, it's caused her to become ill. So she suffered because of this bottle, that bottle of beer. So Mrs. Donoghue went and sued. So the court ruled that she could not sue the shopkeeper because the shopkeeper could not foresee that the bottle had the smell, because the bottle was opaque. Neither could she sue the friend who bought her the beer. So the only person here who could be sued is Mr. Stevenson, the manufacturer of the beer. So Mr. Stevenson, the manufacturer of the beer, also could not be sued because she's the only one who had this legal duty of care. But Mrs. Donoghue could not sue Mr. Stevenson because they had not entered into any contract. Mr. Stevenson had entered into a contract with the shopkeeper to supply him with the bottles of beers. So he is the supplier. So Mrs. Donoghue suing the Mr. Stevenson it cannot happen because there was not direct contract entered between Mrs. Donoghue and Mr. Stevenson. So there was no contract between them. So Mrs. Donoghue was just left there because she cannot sue the shopkeeper, she cannot sue the friend, neither can she sue Mr. Donoghue because they didn't enter into a contract. So that is the case that establishes the elements of negligence. So those elements of negligence. So let us go to the second element of negligence, which is before we go to the second element of negligence, I said that the legal duty of care, under this legal duty of care, there is proximity, just and reasonable circumstances, and the foreseeability. Proximity, just and reasonable circumstances, and foreseeability. As a defendant, if you want to escape this liability under negligence, you must prove that there was no foreseeability, the situation was not just and unreasonable, and there was no proximity, that close relationship. So let us look at the proximity. That for the proximity, one case law, this is a case of Hadley Bine versus Heller and Partners. So in this case, Easy Power Company wanted the plaintiff P to give credit. He asked the banker of Easy Power about the creditworthiness of Easy Power. The banker gave advice that Easy Power was financially sound. The banker went ahead and gave the credit to P. Later on, Easy Power became financially unsound and P suffered economic loss. P argued that they had relied on the advice of the defendant to give credit and thus the defendant should be liable. However, the defendant had excluded themselves by an inclusion liability clause. Because of the disclaimer clause, Easy Power was not liable. So this is a case whereby the plaintiff invested in a company, so he placed credits in this company. So he wanted to know the creditworthiness of this company. So the defendant told him that this company is worth receiving credits, but that was not the case, and Easy Power, the plaintiff, suffered economic losses. So when she went to sue, the defendant claimed that they had issued a disclaimer. What is it? The exclusionary clause, that they are not supposed to be liable if anything happens against the plaintiff, that exclusionary clause. So in the lower court, because of the disclaimer, the House of the Law said that there was liability for negligence. There was liability for negligence, that negligence statement. So there was some close relationship between the plaintiff and the defendant. So that is the proximity. So the defendant was just liable because that close relationship existed. So that's what the court ruled. So before at the lower court they were saying that because of the exclusionary clause that excluded the defendant, he was not liable. But when the case was appealed, the court ruled that there was that aspect of close relationship, the proximity, so the defendant was still liable. So the proximity part has been dealt with. So another element under the legal duty of care is the just and reasonableness. So before the just and reasonableness, we have the case of Kun Yu versus the Attorney General. So this is a case whereby someone had invested in a fraudulent company. So this person invested in this fraudulent company. Instead of suing the company, this person goes further to sue the commissioner. So Attorney General appears as a representative of this commissioner. So this person sued the wrong person. So sues the commissioner instead of suing the company. So this person could not be compensated, and he sues the attorney general or the commissioner for allowing that company to run, yet it was fraudulent. It ran in fraudulent. So let us look at the proximity as under this legal duty of care. So we are looking at the legal duty of care. I said under legal duty of care there are elements: proximity, foreseeability, and just unfairness. So proximity. So for defendant to be liable, the plaintiff must be within the proximity. For a defendant to be liable, the plaintiff must be within the proximity, within the close distance relationship or the closeness in terms of time. So defendant can't be liable if the plaintiff is maybe not in the close distance. So there must be that close relationship, and there are case laws. You have the case of Hadley Bine versus Heller and Partners. Hadley Bine versus Heller and Partners. This case of Hadley Bine versus Heller and Partners, this is a case whereby the defendant went and asked for the creditworthiness of a particular company. So let's assume that the defendant is B. So a defendant goes to someone, let's say D, and asks this D person, can I place my credit to this company? Is it worthy? Then D says that yes, you can place your credit in this company because this company is worthy of protecting your credits, and this company is it's worthy. So later on, the plaintiff suffered economic losses, so as a result of those credits. So when he went to sue, the defendant said that he had placed a disclaimer or an exclusionary clause. An exclusionary clause is just like a disclaimer, so that he was not supposed to be liable of any loss accosted to the plaintiff, so because of the disclaimer. So in the lower court, it was ruled that the defendant D was not liable of any loss suffered by the plaintiff because the defendant had placed an exclusionary clause. We are dealing with this proximity issue, but that proximity issue has not been brought out yet. So when this case was appealed, it was taken further to the High Court. I think it's the High Court, and the High Court ruled that there was that close relationship between the defendant and the plaintiff. Therefore, the defendant was liable of the loss that the plaintiff had suffered. Do you understand? So the defendant suffered losses. The plaintiff suffered losses. So because there was that close relationship, then the defendant was liable. That is the case of Hadley Byrne versus Heller and Partners. Another case under this proximity, we have this case of Home Office versus Rosette and Yacht. Is it Rosette or Cosette? Home Office versus Rosette and Yacht. So, case of Home Office versus Rosette and Yacht. This is whereby a juvenile escaped and went to the yacht. So while this juvenile was in the yacht, he escaped from a postal institution. So he caused damages to the yacht. So this yacht, or the owners of the yacht, instead of suing the juvenile, they went and sued the owners of the postal institution. And this is whereby Lord Wilberforce expounds on this proximity and says that, propounded that there are two-tier tests. There are two tests. For you must ask where there is sufficient proximity. There must be sufficient proximity, you know. So the yacht owners, the postal owners, the postal owners, or the one who own the juvenile, and the relationship between them and the yacht owners, it must be that close. So that is the first test according to Lord Wilberforce, that the two-tier test. The first one is there must be sufficient proximity that creates a prima facie, or a prima facie. So that creates a prima facie that there need not be a rebuttal to know that there is proximity. The another one, it is necessary to consider whether there are any other consideration which ought to reduce the limit, or to limit the scope of duty of the class of period to whom it is owned. If there are other factors which can reduce that relationship, we also need to consider those other facts apart from the ones in the case, other facts which can reduce that clause or the proximity. So there are two tests, the two-tier test. Test number one, according to Lord Wilberforce, is whether there is the close proximity and whether there are other factors which can reduce this proximity or the close relationship. So in the case of UN Kun Yu versus Attorney General, this is also another case whereby someone had invested in a company. So this company was running fraudulently. So this person decides not to sue the owners of the company, but the commissioner who had gazetted that company or allowed the company to run. And he questions that why did they allow this company to run under fraudulent conditions. So the court held that there was no proximity because the commissioner and the one who was offended, there's no close relationship. If that person could have sued the company, then he could have succeeded, but instead he went and sued the commissioner. So the commissioner, there's not that element of proximity, or close relationship. So the case of Hadley Byrne, Heller and Partners, the case of Office and Cosette, and the case of UN Kun Yu versus Attorney General are the ones which establish builds up on the proximity part. So just and reasonable circumstances, we have the case of Hill versus Chief Constable of West Yorkshire. So Mr. Yorkshire was accused of rape. So this Mr. Yorkshire raped the daughter to the plaintiff. So the plaintiff, instead of suing Mr. Yorkshire, went and sued the police. So it was not just and reasonable. How can you sue the police, yet the police is not directly involved? So that is what the court established, that there was no it was not just and reasonable. So the three elements under the legal duty of care is proximity, foreseeability, and just and reasonable circumstances. I hope you are understanding. You are not getting confused. You are just asking the content. So the breach of duty of care. So we have looked at the legal duty of care. The legal duty of care, the things which the legal duty of care and the sub elements which are possibility, the legal duty, the breach of duty of care. This is the second element under negligence. So the breach of duty of care is whereby the defendant has acted in a manner which a reasonable person can't act. So the breach of duty of care is what we actually refer to as carelessness or recklessness. So when you act in a careless manner or a reckless manner, we then say that you have breached legal duty of care. So a reasonable person, according to the law, is that person who is able to act on top of clampers or members. Clampers or members is whereby you are not able to act in overconfidence or apprehension. So if you are not able to act in overconfidence or apprehension, you are a reasonable person. So you are acting on top of clampers or members. That's according to the law. So when you breach a duty of care, then you are acting in a manner which a reasonable person is not expected to act. Thus, you breach the legal duty of care. So there is a case of Blythe versus Birmingham Waters Company Limited. So the court defined negligence in the following words. Negligence is the omission to do something which a reasonable man, guided upon those considerations or circumstances which ordinarily regulates the conduct of human affairs, will do, or still doing something which a prudent or reasonable man will not do. So there are certain standards that courts establishes that a reasonable person should act, or if you act in a manner that is not according to those standards, then you are acting in a manner which is not of a reasonable person. So we say that there are three elements of negligence. There is legal duty of care, the breach of duty of care, and the damages. The legal duty of care, the breach of duty of care that results to damages. So the third element is damages. So the damages, under damages you need to establish that doctrine of res ipsa loquita. So the damages must be as a result of the defendant's actions. So if you are the plaintiff and you want to be awarded, and the case is not as issues or the facts of the case are not as a result of the defendant's action, the defendant is not liable of that issue, then you can't be awarded of the damages, because the omission to do a particular duty results in damages, and that damage must be results as a result of the defendant's actions. So the omission to do, so the damages must be as a result of the defendant's actions. So you have this doctrine of res ipsa loquita, which says that facts need to speak for themselves. You need not to prove the facts must just speak for themselves. For example, in an accident where an accident has occurred, you need not to prove how this person was over speeding or if he was under drugs. The thing you need to prove as an applicant is that as a plaintiff, or the counsel to the plaintiff side, is that indeed the accident happened. If it's as a result of the drunkenness or overspeeding, that is not your business. You are just supposed to prove the accident happened, and the facts need to prove for themselves as a result of the actions of the defendant. So if you are walking and the building collapse and kills people are walking and the building collapse and kills people, those people need not to prove that the building was constructed under wrong circumstances, or the building collapsed because of maybe poor construction. That is not your business. Your business is to prove that indeed people died, and indeed people died as a result of the collapsing of the building. So other facts just need to prove or speak for themselves. So that is the doctrine of res ipsa loquita. So a case law there is the case of municipal Corporation of Delhi versus Sabgwati. The Municipal Corporation of Delhi, due to the collapse of the clock tower situated opposite to the town hall, the main bazaar, Chandni and Delhi, a number of persons died. The clock tower belonged to the Municipal Corporation of Delhi. So the tower belonged to the Municipal Corporation of Delhi, and the Supreme Court explained that the legal position as follows. They explained the legal position. There is a special obligation of the owners of the adjoining premises. So those owners were the one who had the obligations. So that's according to this doctrine of res ipsa loquitur. I hope you're understanding this doctrine. The facts need to speak for themselves. So these owners of this premise were the ones liable. So if you are to appear as a plaintiff side, you need not to prove that this building was constructed under wrong circumstances, or the contractors, or things to do, other things which are not necessary. You just need to prove the necessary factors if indeed people died as a result of that collapsing of the building. That's according to that doctrine of res ipsa loquitur. Another case is of Wakelin versus London and Southwestern Railway Company. I don't know much about that case, but it's just about someone who died in a railway line, but I don't know a lot to do with that case. So it also establishes this doctrine of res ipsa loquitur. So it has been an enjoyable lesson, I hope. So you can comment on the comment section on how to improve these online lectures, and you can also subscribe for those who have not subscribed. So you can comment there so that on how to improve, so that we offer quality lessons. So thank you very much.